The benefits for a student is it gives them an experience that they probably haven't had before, and it exposes them with the notion of a client and a client with a problem. And often clients with problems are very reluctant to really tell you what the problem is, and you have to ferret it out. You have to find out what the problem is, and often that's the difficult part of the task. When first faced with the problem question, they should remember the principal rule of a client interview is it's a client interview, and so put your own egos away, put your own knowledge of the law away, and prepare yourself for a client that may well be nervous, that may be frightened, confused, all of those sorts of things that clients have, and focus on the client. And just remember that one, that it's a client interview. It's not a solicitor interview, it's a client interview.
Before conducting an interview, a certain number of issues must be addressed. First, the interviewer must aim to put the client at ease. Secondly, the respective contact details of the client and the firm must be discussed. Thirdly, the client must be provided with a retainer, and a discussion of costs has to take place. This means you will outline to the client your hourly rate, and following that, you'll discuss issues of confidentiality, whether or not the client has received legal advice before, and then ask the client to outline in chronological order all material facts as they see them. Thank you for joining us today, Mr. Jones. Would you prefer Mr. Jones or Mitchell?
Mitchell's fine.
Okay. Now, before we run into the reason why we're here today, we just need to cover some preliminary issues. First of all, our secretary has passed us along your contact details. What's the best way to contact you? On your home phone? Mobile? All discussions in an interview must be directed at the client. It doesn't reflect well on the interviewers to converse amongst themselves and exclude the client. Our cost agreement. Now, essentially what that is it's a contract which, after signed, will create a legal relationship between us. It outlines our respective rights and obligations, and it also sets down our fee structure, which is $200 per hour. Although, as noted by our secretary to you on the phone, this first consultation is absolutely free, so we'll only begin to charge you after you've had a chance to read. Throughout the interview, continually ask if the client understands. This will ensure that you're on the same page and that no issues are missed.
Now, I need to ask you at this stage whether you've received any legal advice on the matter which you're coming to see us about today.
No, I haven't.
No, you haven't? That's completely fine.
The interviewer should always aim to use plain English. What this means is that the interviewer should not use words such as equity, quantum, vitiating, and indemnity.
After the client has given you the initial overview of their problem, the next step which you will have to take is to identify each specific issue in the client's problem and then ask exhaustive questions about each specific issue in chronological order. Now, the way the interview is going to work is we're going to, in a moment, ask you to tell us why you're here. So you'll tell us about the issues which you've been having. Cody and I will be making some brief notes throughout that. Then, for each of the issues that you raise, we're going to go into each of those in a little bit more depth, so we can really nut out what all the facts are and what all the information about those are, and then hopefully provide you with some advice and avenues which you may be able to consider depending on where you actually want to go.
An interviewer should always be non-judgmental and display courtesy and be respectful of the client's emotions and feelings.
The one thing that you should always remember when conducting a client interview is what does the client actually want to get out of this scenario, and how can you, as their solicitor, best help them achieve that end.
The most common mistake that students make, that I've seen as a judge, is they completely throw away 20 marks because the way the structure is set, there's 80 marks for the interview and that process, and there's 20 marks for the after interview, the wrap-up, where they talk about what's happened and what they're going to do themselves. And I've seen it time and time again. Students just, all the energy's gone. They say, oh, the interview's over, and they just sort of close out without any real detail, without any real effort to sum up in their minds and to get themselves organised, and that's 20 marks thrown away.
Okay. Now, if you could please tell us everything about why you're here today. And when I say everything, I really mean everything, because even it may seem quite insignificant or small from your perspective, but from a legal perspective, it could be very important. So it will also save us time further down the track if we can really nut out as much information in detail as possible today.
Okay, so essentially I'm a large-scale property developer with my wife.
When conducting an interview, it's important that one interviewer always maintain regular eye contact with the interviewee. If you do not know the answer to a legal issue, do not pretend you do. Explain to the client that you'll conduct further research and revert to them on that point.
Techniques. One of the things that is most important is to know when to use an open question and when to use a closed question. And you have to use them both to solicit various types of information. But that's one of those difficult judgmental things and practice things. It takes practice and time. An open question allows the client to say things in their own words, to tell their own story, and to tell it in their own time, and to use their own language and feel comfortable as they tell the story. A closed question is something that you use probably as the second line, and that is when you need to know things. And the danger with a closed question is if you ask it too early, you can shut the client down. You can focus them too much on a single point. They then think that's an important point, and they'll expand on that single point. But you need to know the full story or get a sense of the full story before you start asking closed questions.
Thank you for giving us that overview. Now, if it's okay, we're going to try and build up sort of a chronological timeline and firstly ask some preliminary questions about your neighbour.
Sure.
Yep. So could you tell us more about your relationship with your neighbour, how long you've known your neighbour for, have there been any incidents in the past, anything like that?
Well, I've known my neighbour for about 2 years.
Upon reaching the conclusion of the interview, it will be important to recover the issues which were raised in the interview summarily. A helpful way to do this can be to provide a written summary of the meeting to the client and also outline any follow-up action both for the solicitors and also for the client. A problem many client interviewers face is getting all the information out of the client and then also giving the client advice in the brief 30-minute interview period. One way to overcome this challenge is to have pre-established time periods for different segments of the interview in your mind already before commencing the interview. It is, however, important to be flexible with these time periods.